floor is yours. Thank you again.
Okay. So hi, everybody. Good afternoon. It's a great pleasure to have you all. Today, we're going to discuss Tomer Shadmy's paper, From Users to Humans, Reimagining Political Freedom in Online Platforms. Some word about Tomer Shadmy. She investigates the legal, ethical, social, and political challenges associated with the governance of emerging technologies, such as artificial intelligence. Ms. Shadmy received her PhD from Tel Aviv University Faculty of Law, and she is currently a research fellow at the Hebrew University of Jerusalem and the Institute of National Security Studies. Professor Ronit Donyets-Kedar will present the paper and comment on it, and the schedule is going to be the following. First, Ronit will have 15 minutes to present the paper and comment on it, and then the author, Ms. Shadmy, will then have 10 minutes to respond, and then the floor will be open for discussion with all participants. So, Tomer, the floor is yours.
Oh, I think it's my turn, no?
The floor,
Ronit.
Yeah.
The floor is yours. Sorry.
Yeah. So after causing so many problems with the audio connection to this thing, I apologize for the delay. And Anat, thank you for trying to help. In private, I couldn't respond fast enough. So, focus on what's at hand. So thank you very much. And for organizing such a wonderful conference, which I constantly learn more and more stuff from people's lectures. So thank you very much. And it's a privilege to be able to comment and respond to Tomer's paper titled From Users to Humans, Reclaiming Online Political Freedom. I really like Tomer's work and I enjoy it, and I share her enthusiasm for curbing corporate power generally and specifically when we talk about platforms. So that's really a great opportunity for me to think about these things through your paper. So what I'll do is I'll briefly describe and go through Tomer's article. And I can't do justice to all of it, but with a short presentation, but I'll do my best to focus on the important stuff. And then I'll say some things that I thought may require some more thought or discussion generally. So if I want to sum up Tomer's proposal in one sentence, it would be that we want to create net unions, unions for users online, users of large platforms or internet platforms that will enable to create a voice and involvement of users in what Tomer identifies as the regulation of these platforms upon users. So Tomer shows that there's a constant state of affairs where platforms regulate users all the time, but unlike standard regulation, where in a democratic society anyway, where participation is part of this regulation, under this regime of private platforms, the part of involvement and participation is lacking, and that carries a lot of different threats that Tomer sheds light on. So the power of platforms here is translated into the power to regulate, not just saying they're strong, they're controlling stuff, but it amounts to the de facto regulation without participation. So that is wrong, and that undercuts what we think about democracy and regulation generally. So Tomer starts out with identifying the regulatory amalgam of the platforms, and she analyzes the similarities and differences between the platform regulation mechanisms and classical or standard regulation, and shows the threats and perils that this type of regulation carries with it. And then she offers a solution in the form of these net unions. So the paper, because you didn't read the whole of it, just or some of you probably haven't gotten to reading all of it, just the highlighted parts, I'll I'll try to go through the whole thing. Maybe it will give a broader understanding of the whole move. So Tomer starts out with describing the conditions for the rise of power, of regulatory power of the platform corporations, and highlights especially private law regimes, which stresses freedom and consent, within which platforms operate. Then she highlights their operation within the transnational cyberspace, which means that there's no one state force that could actually counter their actions, which in turn results in the platforms being kind of a semi-sovereign, or maybe not so sovereign power to regulate. Then she moves on to talk about the neutral algorithm, which I think is a great point, because it's kind of this mathematical non-human, allegedly, or we perceive it as this non-human, mathematical, scientific, sterile, non-biased mechanism. It distances the platforms from the results of their actions. And so regulatory regimes from the state top down on the algorithms sounds a bit irrelevant, right? It's mathematics, right? What exactly do you want to regulate here? It's not people who decide and make mistakes. It's this wonderful logical system that does that. And the same thing goes for the participation of users. It's less relevant, right? It's not what we say or what you say. It's not about opinions. It's not about your view. It's about, the scientific decision-making of the algorithm. And so on one hand, regulation is less needed. On the other hand, participation is allegedly less needed. But as Tomer shows and does that well, it's a mistake to think like that. The following move is to analyze the regulatory layers of platforms. She starts with terms of use, which we all know and love. Yeah, the contracts that we keep signing and re-signing whenever they want. She moves on to a beautiful discussion of the interface and how the interface itself is a regulatory mechanism. Default rules, opt-in, opt-out. All of these are very law-like in the way that they regulate the user's use of the platform. And then she moves on to talk about the algorithm itself, which is a mechanism of decision-making, which kind of paves the road or the path upon which users walk on, and therefore it regulates where they go. So if the road takes you left, you have to go left. If it takes you right, you have to go right. So by forming the road, the regulators actually do that throughout the use of the users. Then comes the one of the really interesting and theoretical parts of the paper, which Tomer talks about the jurisprudential features of the special regulation. And here she tries to show how platform regulation is very different from ordinary regulation, and undercuts the Western liberal ideal of the rule of law and the principle of legality, and how if we are responsible for what we chose and did. So she talks about 4 types of differences, but I'll focus only on one of them. The first one, which is the claim that the algorithm creates a type of regulation that is not universal and is not based on causality as the normal, regular parts of regulation, but rather it is personalized, and it leads to correlation rather than causation. So Tomer shows how the algorithm treats people through a proxy of belonging to a certain group or a subgroup, and then decides on how to act on this type of group. So if I'm a part of the group of people who move the mouse slowly, then I will be deemed for a certain outcome, regulatory outcome. by the platform. So it's not that the person's behavior is what leads to the result, the enforcement type result, but rather this either the correlation between belonging to an imaginary group or actual groups that the algorithm has been able to identify. And one of the things that I like most about the paper is that Tomer stresses how these practices, all of the ones that we talked about, the amalgam of regulations and the differences between old regulation and platform regulation, is not, it doesn't only touch on infringements of what we're used to talking about, privacy and human rights in the narrow sense, but rather that has a much larger and deeper impact on the political sphere. So Tomer insists that these practices of regulation by private powers goes against our collective self-rule, political rights. It shapes the public sphere in really bad ways that we need to answer to. And she shows throughout the paper exactly how that happens and how the public of users, maybe the republic of users, is not part of it. So it's a top-down mechanism of regulation that does not involve participation or involvement by the users, but doesn't touch only on the specifics of personal issues, but rather shapes the entire public sphere. And this ties to my own work, which is trying to discuss the same thing. So I really liked the way that you did that here, Tomer. The next move is to show that the legal tools that we have now aren't sufficient, especially those from public law. Tomer says that there's an impasse of public law. That's how she calls it, especially for two reasons, which I completely agree with. The first is that there's not a good enough theory to discuss corporate power in terms of the political aspects of that corporate power. And the second one is that there's not a good enough theory to think about democracy outside the realm of the state. So while I do think that Tomer may be too quick to dismiss the public law application onto corporations and especially platforms, I do share the sentiment that we need more. There's so much going on here. It's such a tremendous change to the rules of the game and to public life as we know them. And I completely agree with more needs to be done. Now, what Tomer suggests as this comeback by this pushback by the public of users is to establish legal structures that will enable the creation of net unions as representatives of platform users. They will be elected by users. They'll be allowed in to all these secret meetings in corporations, and they'll look into the guts of the black box that makes the operations of everything going on. They'll suggest improvements on behalf of the public of users, and they'll owe fiduciary duty to the users and have confidentiality duty to the platforms. The important thing for Tomer, if I understand correctly, is that they'll enable a collective voice via collective action. So it's not just an ordinary participation. So what I wanted to say, I want to push you a little bit on the community and what is the relevant community for your project, and maybe a little bit to carry or to draw on what Shelly was talking about yesterday about what a crowd is, because I think there's a latent assumption behind your paper that there really is this one voice for users. And I'm thinking that if there really is this one voice for users, but it just doesn't, there's no way of communicating that voice, then maybe the right way to go is still with old-fashioned regulation, whereby the state would tell the platform, we don't like you doing X, stop doing X. And now if we think about the state as a democratic entity, then that is a representative as well as the net unions. So it's still a democratic solution that that tackles exactly what you're worried about, the no voice issue. If, on the other hand, there is not just one voice, but many voices, and there's a multitude of issues, then in this case, I think you need to define in a more nuanced way who the crowd of users is. Because according to some definitions, a crowd is exactly that dispersed, non-homogeneous, conglomerate of individuals, rather than a group or people who share similar interests. So I wanted to know, yeah.
Ronit, I apologize for interrupting. You have another 2 minutes, okay?
2 minutes, yeah, no problem. Okay, so in terms of the voice, if it's a one voice, then the maybe the state is a better idea. If it's many voices, maybe we haven't done enough to define what the constituency is and what the bargaining unit is, to draw on labor law definitions. So that is the first thing. The second thing is, and I'll finish with that, although I have some smaller issues that I'm happy to talk to you separately about, goes to your jurisprudential distinction between this correlation and causality. I agree completely that that's what's going on within the algorithm world. I wonder, however, if it's not the same thing in standard law. Well, we don't like to think so. The ethos is that we have, it's the results of our actions stem from our choices and our own behavior, and there's this accountability, old-fashioned, nice accountability, but I'm not really sure that that's the way the law actually works, because giving a lighter treatment to celebrities happens in regular law as well. Whites, rich people, strong people, people with money, they get the better deals out of whatever. Regular law does profiling exactly the same. So if you're a part of this group of Black people or women or Arabs in Israel, then the mere participation or belonging to this group usually carries a lot of weight in terms of the results of what would happen to you in court. So all of these things are already happening in law. Not just that, it's even deeper than that, because the power structures within law are arranged to benefit the powerful. CLS has taught us that a long time ago. So think about consent in sexual offenses. Think about, corporate tax and the ability of some to go to tax havens that's not open to the rest of society. So the whole structure of law is already tilted towards some groups, and by being part of them or not being part of them, that carries weight within regular law as well. So even the principle of the seamlessness, that kind of behind the scenes workings, is what's happening in law as well. So is it really that different, or is it a qualitative different, or is it that we're worried about? Or maybe it's just the fact that they are private powers, and while the state we still have some access to, we don't in the case of corporations. So thank you, and sorry for all the glitches of technology.
Okay, thank you very much, Ronit. Though there were several technical issues, the presentation was very clear, and thank you very much for the thought-provoking comments. Tomer, the stage is yours.
Okay, so thank you. It's such a great privilege to participate in such a conference and to get a comment from Ronit, which I personally really adore her scholarship. So Thank you, and thank you for the brilliant comment. So what I want to do is first just in general to describe the project, and then to answer to Ronit's main two interesting comment. So in this project, what I wanted to do is to try to redefine the discourse about the platform powers, because we usually speak about the impact of platform on concrete human rights, privacy, freedom of speech, property right, labor right. We spoke yesterday, and I want to discuss the power of platform to legislate, to enforce norms, and to regulate the behavior of users and communities in general. And I think we have lack of conceptualization and tool to understand and think about this kind of power because of two reasons. First, it's a new kind of entities, this global platform. And second, and in a way more interesting, they have a new tools for governments, a new tool for regulation, the digital tools that have some unique jurisprudential feature, which Ronit also described. And I think those two components together bring a lot of challenges to our conceptualization, and then to the way that we regulate those kind of powers. So this is in general my ambition here. And first, and what was important to me is to say that state regulation is super important. I don't think that we need to abandon it and to try to reimagine new kind of regulation, cloud-based regulation. No, I think that new kind of regulation in issues like privacy, competition, freedom of expression is super important and super relevant, and it's going on those days in very extensive volume in Europe, also in the US, in China, everywhere. So I think it's super important, and all my suggestion here is not because I think that those kind of regulation are not relevant, but I think that we need another layer of regulation because of the very unique kind of entities and new kind of regulative tools. So I think it's one more kind of regulation, not alternative kind of regulation. And why do I think that we need this kind of regulation that grant voice to the user? Because I think that even if we would have because of competition law and antitrust, we will have 7 Facebooks and 4 Google. And I think that we still, and all these 7 Facebook and 5 Google will have the perfect privacy policies and the perfect content moderation policies. I think that still we will need this kind of regulation that grant voice. Like in labor law, for example, we have those legislation that give a right to workers, like a minimum wage and other things. And we also have this infrastructure for granting the worker voice and collective voice. Because the relationship between the workers and the employee and the employer are ongoing relationship with a great power gaps. And because of that, we think that it's not enough that we will have just legislation to protect the worker. The worker need also a voice because of this very unique kind of relationship. So I think in platform, we have a lot of similarity to this kind of relationships, because in this scenario that we have 7 Facebook, still Facebook and Google will have very intimate relationship with me, because I have it's ongoing relationship, and they direct me, they control the way that I have a relationship with my social interaction. They control the way that I have access to knowledge, that they control the way that we all as communities have political discussions. So because of this very new kind of powers, it's not like powers that we can think, okay, this used to be state power and now it's privatized. No, it's a new kind of power to shape our relationship, to shape our access to knowledge. And because of this intimacy, we need to have some voice in shaping these spaces. And we need to have voice as individual, which those companies shape our spaces. And we need to have voice as political communities or as communities. So because of that, I think that it's not enough that we will have our political voice through the states. We also need political voice in a way, or political participation inside the platform, like we have in the workplace. And another reason why we need it, I think, and it's related to what Ronit described as a personalized law of the platform, is because if we look through the algorithmic gaze on individual, how algorithmic or how this machine learning system imagine the individual, they imagine individual as like collection of data points and they assume that we will behave like the other people in the group that have the same data points or something like this. And because this is change in the individual and doesn't look on individual as a political creature, as a social creature, I think that we need to have a voice in order to mitigate this understanding of the individual. So I think because of those two reasons, I think that having a collective voice is super important also in these kind of spaces. And having said that, I completely agree with Ronit about the comment on the community. Who is a relevant community? Because political participation is depend on, and it's like also organize a community, and we need to assume some community. And here, like 2.5 users are not billion users are not community. But I think there's a lot of regulative imagination and innovation we should do in order to think about how to organize this kind of voice inside the platform. And I don't think that in this paper I can offer the whole solution. So I think that in this paper, what I wanted to say that we need this kind of voice, and it's separate voice than the voice that we have in the state, and we still have to have political voice in the state, and we still need to have regulation through the state, but we need another kind of regulation. Another kind of voice. How to organize this kind of voice, I still don't know. But I do think that we need some local communities, like maybe to vote for representative in our local communities, that they will represent us vis-a-vis the platforms. And so I think that we need to rethink all the corporate governments in this issue, and not in every and each issue in the platform, but in some issues that really influence the users, like freedom of speech issue, like controlling the data of the users. And I think this did have to be collective voice because of the great power relation. Because if I go to Google and say, oh, this is not right what you're doing, it's nothing. But if we have collective power, then it may have more interesting result. And there's a lot of attempts in the platform through all the years to try to say that, okay, we will democratize our community standard, for example, and give some rights to the end user to choose between different kind of regimes. There was some attempt like this, but in all those attempts, the platform look on the users just as individual, and then it gives them like a manual, like just choose between 1, 2, or 3 options. And for example, it's very similar to the privacy regime. You can choose whether to have this cookie or that cookie, and this is your own choice. And I think it's just an illusion of democracy in this way, because in this kind of regime, we are just choosing, like we choose yogurt, so we choose our normative universe, our law. And I think law should have based on political participation, which is political, which is collective, because this kind of law is also shaping our political communities. So
Tomer, I apologize for interrupting you. You have another 2 minutes. Thank you.
Okay, so I think in general, but I do totally agree with Ronit that we have a problem of what is a community here. For example, I know that inside those platforms, they look on certain states. They don't, for example, they don't look on Israeli citizen or Israel, but on market. They call it market, the Israeli market, the European market. So, and I think that we can base on some local understanding, like each user will like choose. I can choose whether I want to be part of like the Israeli user or other user, and we have like different unions, and I can choose whatever a representative that really understand this platform in order to represent me in the different decision making inside the platform. So I don't think that I can in this paper just rethink the whole governance of this kind of issue, but what is important to me is to speak about voice and not exit right in this kind of relationship with platform. I think this is for now, and now I really, so really thank you, Ronit, for your remark, and a lot of my conceptualization and understanding of the public-private distinction and the power of cooperation comes from your scholarship. So thank you also for this.
Okay, so Tomer, thank you very much for your interesting reply. And now the floor is open for discussion with all participants. You're all invited. Are there any questions from the audience? Yes, Alon, and then Gila, Shelley, and Boaz.
Hi, Tomer. It's a great paper, and I like the direction you take it. And I want to push you on one of the things that was raised, I think, implicitly in Ronit's comment, and another small thing. So first, there's a question of whether is it all new, and are the direction you want us to take should be constrained to technological platforms, because a lot of what you said could be also related to insurance companies, banks, infrastructure providers, as you know, that I'm interested in, and other private companies that have a great measure of power over individuals' life. And I'm not sure that the way you constrain it to technological platforms is convincing enough by itself. And it also relates to the question of whether it's really an attack on the corporation and the multinational corporation as a political structure, or is it just about technological platforms? Another issue is I think that it could be interesting if you developed a bit more your notion of voice, because of course voice is a loaded term, whether it refers directly to Hirschman, and then the question of exit versus voice in markets is really instrumental or important to distinguish here, or is it more loaded with other meaning? Could be more related to what Tamara later will present regarding a Republican kind of notion of the polity, or what do you mean exactly by voice? I think there's room to develop it a bit more.
Okay, thank you very much, Alon. Thank you. So since we had some technical issues at the beginning, we'll first, and we have some time constraints, we'll first take the questions and then Tomer will have the time to answer them, okay? Is that okay with you? Great. So Gila?
Yes, so thank you very much, Tomer, for a really fascinating paper. And I think it just shows, through this whole workshop, we're struggling with ways to resolve these problems that allegedly haven't been, thought of before, haven't occurred before, but maybe they have, and we're just not making the proper connections. And in this respect, and to continue Alon's line of thinking, so I'm kind of bothered with, maybe I'm not really understanding correctly, but these net unions seem more privatization. So like we're leaving the state out of everything. We're doing everything privately. And if we're doing things privately, I'm not sure how powerful we're going to be in this context. So I was thinking maybe more along the lines of public councils that come, next to all sorts of regulatory bodies and can hopefully at least affect the way that those regulatory bodies work. And those regulatory bodies come with the authority of the state. So I was just wondering, in this public-private, question, are you not giving up on the state too quickly and going to the private sphere in which we as a crowd, as individuals, as whatever you want, are bound to lose?
Thank you, Gila. Shelley?
Okay, so thank you, Tomer. This is a really great project and sort of adds up to your scholarship in this really interesting way. And so I'm going to, in a way, continue with the comments that sort of try to push you a little bit about your status quo bias, right? So you mentioned, you acknowledge in the paper that there's something about the argument preserve the status quo in a certain way, and even in your reply to Ronit, you talk about even if there are 5 Facebooks, right, we will still want to give voice to users, and I accept that. But what I would like to suggest is why not encourage instead platform alternatives? And I'm thinking in particular about cooperatives that are inherently democratic and based on voice. So for example, there is a cooperative alternative to Uber. I think it's called Co-op Ride or something like that. And so we need perhaps maybe the state needs to create the proper regulatory conditions in terms of taxes, antitrust, maybe other types of regulation that will encourage more democratic or cooperative forms of organizations, other than just accepting the status as it is and trying to improve it a little. But it's a fascinating project, so thank you.
Thank you, Shelley. Boaz?
Thanks for the paper. I'm torn. On the one hand, I think you're right that only the state can be powerful enough to regulate those giant multinational corporations, and we need regulation. On the other hand, I'm thinking about all of the small quibbles that we might have on online platforms. For example, if I post a meme on a parenting meme group on Facebook and an administrator deletes my meme because he or she thinks that it violates the community rules, which are not set democratically, by the way. And I'm very upset about it. And I have no kind of way to appeal this. And this is a very small and tiny incident, but still it can cause people some emotional, they can still get excited about it. And I'm thinking, bringing in the state as a regulator in such cases seems like an overkill. So maybe, I don't know, maybe we should think more about kind of voluntary regulation, community regulation, things that you do talk about, but I'm not sure that local form of government, something, it works more or less well in Wikipedia, those forms of community, of users, self-regulation, or just change the design of the platform in a way that will nudge people to make more responsible decisions. So not address the problem through regulation at all, but through other means that have to do more with, I don't know, socio-technical engineering.
Okay, thank you, Boaz. Shelly, Tamar, is that okay if we will allow Tomer 5 minutes to reply? We had some technical issues at the beginning, so we're...
Yeah, that's fine.
Great. So, Tomer?
Okay, so I try to do it really fast and to take to my own consideration all the comment after it. Anyway, so first, I didn't react to Ronit a comment about the way that maybe the law, also the law of the state, is personalized law and it treats differently different kind of person and communities. So I do agree completely. But the thing that we still have the principle, the ethos of the rule of law, like formal equality before the law, as a way to criticize different appearance of the law. But the way that law that is based on machine learning, that in the first place, the logic of the law is personalized logic. So it's not like that we have some problem, some accident with the law and we need to correct them. That in the first place, the logic of the law is in very hard tension with this principle of the rule of law. So and the question whether we need to change this principle of the rule of law or whether we need to challenge the use of machine learning for certain missions. So this is for Ronit. And then for Alon and Gila, about the first, yes, I do think that we should have different democratic mechanism beyond this, also beyond the state. So it's not just platform, it can be in other places, but I think that, again, there is something very special in the power of the internet giant that we should look in particular on this issue. And this is for Alon. And for Gila, I think it's not, again, I think that we need state regulation, and we need it. I'm not saying that we need to abandon it and to think about a new kind of regulation. I think that, like trade union and labor union, it's not instead of legislation, of state legislation, it's another part of state legislation. In the way, and it's also it will be possible only if state will oblige platform to do so through law. So state will need to have some legal infrastructure in order for this to exist. But I don't think it should be instead of, but another kind of response. And again, to Shelley in the same issue. So I do think that we need also to think how the law enable and create legal infrastructure that will give incentive to co-ops, for example, to data co-ops. I'm part of a group of researchers by Katrina Ligat from computer science in the Hebrew University and Kobe-Nissim from Georgetown that's called data co-ops. And we need to, and there we try to reimagine the whole data system in order and to think whether we can think about different kind of regime of data. So I don't think we just need to look on the contemporary platform, but also to help to rebuild other kind of platform. But I think again, it's not instead, but one more. It's like all this online environment. It's not like we don't have like one a golden solution that will fix Facebook and fix our entire online environment. We need a lot of kind, like, because online environment is like the city, for example. It's not like just one kind of law will save the city. We need many kind of law in many kind of issues. And to Boaz, again, I think in this case, for example, when we have a problem with particular content moderation, I think the unions of user could be really helpful. And I think what state should do is oblige platform to have a mechanism for that we can apply to them and have some connection to them. But I think, and if the platform cannot offer it to us, we can just call our local user representative and say, okay, do something because we have this problem. So I think exactly for this kind of problem, this user union can be really helpful. Okay, so thank you so much. And you gave me a lot of food for thought, and thank you.
Okay, so Tomer, Ronit, and all participants, thank you very much for a very interesting session about a fascinating topic and paper. I wish you all a nice day and enjoy the rest of the conference. Goodbye.
Thank you.